Madam President.
Senator from Massachusetts.
Thank you, Madam President. Madam President, I rise to speak in opposition to the nomination of Judge Neil Gorsuch to serve as an Associate Justice of the United States Supreme Court. Let me begin by making clear my view that the vacancy on the Supreme Court created by the death of Justice Antonin Scalia was President Obama's to fill. But in an act of unprecedented obstructionism that makes a filibuster pale in comparison, Senate Republicans broke with long-standing Senate tradition and refused to hold a vote or even a hearing on President Obama's nominee, Judge Merrick Garland. As we now consider President Trump's nominee, Judge Neil Gorsuch, we cannot ignore or forget this hyper-partisan action. We also cannot ignore how Judge Trump came to nominate Judge Gorsuch. President Trump went to two of the most partisan conservative organizations which he could find: the Koch brothers-supported Heritage Foundation and the right-wing Federalist Society, and said to them, "Who do you want on the Supreme Court?" And they compiled their dream team of 21 ultra-conservative candidates. President Trump looked at the names on that list and asked himself which judge could pass the right-wing litmus tests he had articulated during the campaign. His choice was Judge Neil Gorsuch. On the campaign trail, candidate Donald Trump made clear that he was pro-life and would appoint pro-life judges to the Supreme Court. In one interview, he was asked about his pro-life position as follows. Here's the question posed to him. So, how important is that issue to you now? When President Trump picks the Supreme Court justices, would there be a litmus test? Trump responded, quote, "It is, it is." During the second presidential debate, candidate Trump doubled down on this issue. He was asked specifically about Roe versus Wade, the long-standing Supreme Court precedent establishing a woman's right to choose. The question to candidate Trump was, quote, "Do you want the court, including the justices that you will name, to overturn Roe versus Wade?" Trump responded that he would, quote, "be appointing pro-life judges," adding, "well, if we put another 2 or perhaps 3 justices on, that will happen," meaning Roe versus Wade will be overturned. So we know from Donald Trump's own words that he had a litmus test for Supreme Court nominees on a woman's right to choose. And that litmus test is that he will appoint only pro-life justices who are committed to overturning Roe versus Wade. What about a litmus test on guns? Well, during the presidential campaign, candidate Trump repeatedly emphasized his pro-gun views, which are in lockstep with the National Rifle Association. He was asked about a litmus test for the Second Amendment, specifically the precedent established in the 2008 Supreme Court case of District of Columbia versus Heller. In Heller, the justices ruled 5-4 that a common-sense Washington, D.C. law banning handguns and requiring other firearms to be stored, unloaded, or locked violated the Second Amendment. Candidate Trump was asked, quote, "Will you make upholding the Heller decision a litmus test in Supreme Court nominees?" Trump answered, quote, "Yes, I would." The follow-up question: so you won't nominate somebody to the Supreme Court unless they agree with Scalia on the Heller decision? Trump responded, quote, "Correct." So we know from Donald Trump's own words that he had a litmus test for Supreme Court nominees on guns. His judges must support the National Rifle Association's agenda and its unreasonable and dangerously broad view of the Second Amendment. So, from that list of 21 names provided to him by the Heritage Foundation and the Federalist Society, President Trump chose Judge Neil Gorsuch, apparently convinced that he was the man who would pass these litmus tests. The Senate Judiciary Committee's hearings on Judge Gorsuch were an opportunity for him to dispel doubts about his independence that President Trump's selection process had raised. Unfortunately, Judge Gorsuch did nothing to address these concerns. In fact, his appearance before the Judiciary Committee raised more questions than it answered because Judge Gorsuch was positively Sphinx-like before the senators questioning him. For example, when repeatedly asked about something as elementary as his judicial philosophy, Judge Gorsuch refused to answer. He declined to say whether he agreed with the Roe versus Wade decision, the District of Columbia versus Heller decision, or other controversial decisions like Citizens United, which opened the floodgates to unrestricted secret money in electoral campaigns, or even the decision in Bush versus Gore, which decided the 2000 presidential election. Judge Gorsuch also refused to respond to whether he agreed with other important Supreme Court precedents on the right to privacy, the right to counsel in criminal proceedings, voting rights, or same-sex marriage. Contrast that to Justice Sonia Sotomayor, who during her confirmation hearing explained that she fully understood the individual right to bear arms that the Supreme Court recognized in the Heller decision. Or contrast that with Justice Anthony Kennedy, who during his hearing praised the Supreme Court's landmark 1963 decision in Gideon versus Wainwright, which established the right to counsel in criminal cases. Or even contrast Judge Gorsuch to Chief Justice John Roberts, who at his hearing affirmed that privacy is part of the liberty interest protected by the Due Process Clause. Instead, at his hearing, Judge Gorsuch repeatedly parroted that critical Supreme Court decisions were precedents of the court that he would follow unless and until they were overturned. But he shed no light on what he felt about those precedents or whether or not he would be inclined or disinclined to vote to overturn them. Only after considerable prodding did Judge Gorsuch eventually agree that the decision in Brown versus Board of Education, which did away with the doctrine of separate but equal and desegregated schools across our nation, was correct. Having to pry out of Judge Gorsuch that concession does not inspire confidence in him. So, his performance at the hearings left us with many troubling things that we don't know about Judge Gorsuch. But equally troubling about Judge Gorsuch are the things we do know about him. We do know that Judge Gorsuch authored the Hobby Lobby decision, in which he ruled that corporations are people whose religious beliefs are more important than the reproductive rights and health of women. We do know that Judge Gorsuch has questioned the judicial doctrine of what is known as Chevron deference. That's the rule from the Supreme Court case of Chevron versus the Natural Resources Defense Council, under which judges must generally defer to expert administrative agency interpretations of laws they are charged with administering. In a speech last year, Judge Gorsuch attacked the modern administrative state that has developed under Chevron, saying, quote, that it, quote, poses a grave threat to our values of personal liberty. What Judge Gorsuch is saying is not some abstract legal theorizing. He is attacking the fundamental rules that protect the health, safety, and welfare of all Americans that are put in place by agencies like the Environmental Protection Agency, the Food and Drug Administration, and the Securities and Exchange Commission. In the decades since Chevron was decided It has been instrumental in courts upholding these agency rules that ensure that our air and drinking water are clean, rules that ensure that drugs and medicines are safe and effective, rules that ensure that our automobiles, workplaces, food, medicine, and children's toys are not dangerous, rules that ensure our financial markets are fair and offer investors a level playing field. Even Justice Scalia supported Chevron deference. But Judge Gorsuch has signaled that he would overturn it and instead allow pro-corporate judges to substitute their policy views for those of the agency experts. If threatening the destruction of the regulations that protect the health, safety, and welfare of Americans sounds familiar, it should. It's straight out of the alt-right Steve Bannon playbook. And it is a fringe position that is not worthy of representation on our nation's highest court. We also know that the Supreme Court just rejected Judge Gorsuch's harsh reasoning in a disabilities rights case. A few years ago, Judge Gorsuch wrote an opinion for the 10th Circuit Court of Appeals in a case under the Individuals with Disabilities Education Act. That opinion held that schools across the country must provide educational benefits to students with disabilities that, quote, must merely be more than de minimis. But just last week, in an IDEA case, all 8 Supreme Court justices disagreed with Judge Gorsuch. Chief Justice Roberts wrote that the IDEA, the Individuals with Disabilities Education Act, is, quote, markedly more demanding than merely more than de minimis test applied by the 10th Circuit, and added that Judge Gorsuch's approach would effectively strip many disabled students of their right to an education. We also know that Judge Gorsuch has consistently ruled against employees in cases involving claims of unsafe workplaces and sex discrimination, and has repeatedly sided with insurance companies that sought to deny disability benefits to employees. Here's something else we know. If the first 75 days of the Trump administration are a preview of coming attractions, one thing could not be more clear. The United States Supreme Court's rule defending the Constitution will be tested as never before. Conflicts of interest, emoluments, Muslim bans, rescinding LGBTQ protections, the list of constitutional rights the Trump administration is violating gets longer every single day. Now, more than ever, we need a Supreme Court justice who is independent and not beholden to ideology. Now, more than ever, we need a justice who will stand up for the rights of all Americans against big corporate interests. A justice who would be to the right of Antonin Scalia on the issue of Chevron deference is not a mainstream justice. A justice who would be to the right of Samuel Alito and Clarence Thomas by a substantial margin, as professors from Michigan State University and the University of Wisconsin concluded, examining Judge Gorsuch's opinions from the 10th Circuit and the Supreme Court's decisions reviewing them, is not someone within the mainstream of American jurisprudence. Everything that we have seen so far, from Donald Trump's judicial litmus test to the visible hand of right-wing interest groups in the selection process, to Judge Gorsuch's reluctance before the Judiciary Committee, to his pro-corporate bias in cases he has decided, leads me to the conclusion that he will be neither a justice for all Americans nor one on whom we can count to stand up to President Trump. We cannot let Judge Neil Gorsuch become the crucial 9th vote on this Supreme Court. One justice matters. The list of recent 5-4 decisions coming out of the Supreme Court shows that one judge's vote can forever alter history. Just remember that Bush versus Gore, Citizens United, District of Columbia versus Heller, the Affordable Care Act were all decided by 5 to 4 votes. I will, therefore, oppose Judge Gorsuch's nomination to the Supreme Court and support the filibuster. And I urge my colleagues to do so as well. If Judge Gorsuch cannot muster 60 votes, the problem is not with the process, it is with the nominee. If Judge Gorsuch cannot get to the 60 votes historically required for confirmation to the nation's highest court, I urge President Trump to withdraw his nomination and consult with a wide range of senators, legal scholars, and others that past presidents have sought out before making a Supreme Court nomination, and put before us someone in the mold of Merrick Garland, who can enjoy bipartisan support and be within the broad mainstream of American jurisprudential history. Otherwise, the consequences of forcing Judge Gorsuch's nomination through will fall squarely on the shoulders of President Trump and his Republican allies in the Senate, and if they decide to exercise the nuclear option, forever changing the history of the United States Senate. I urge a no vote on Judge Gorsuch, and Madam President, I yield back to the chair.